Okay, well, we're going to go ahead and get started. A couple more people might end up jumping on, but we will go ahead. Before we get started I was basically going to go over the listing agreement and the purchase agreement. Are there any specific questions that you have about any documents that we should cover today? Okay, if anything comes up, just go ahead and unmute yourself, or you can put it in the chat box. Either way works for me. So I'm going to share my screen. Okay. Go ahead and get started. Good morning, Nikki.
Good morning.
All right. Okay, so first I just started with our purchase loop checklist because I did recently reformat these just to be completely accurate for what's required right now. So the consumer guide, we know the MLS full printout, agency disclosure, offer to purchase, property disclosure, lead-based paint, Ohio Real Title affiliated business arrangement to show that we have a relationship with Ohio Real Title at our office. America's Preferred Home Warranty application either accepted or waived because they will pay a portion of any errors and omissions claim that would take place during the course of the transaction, as long as we have that on file. The COVID addendum is highly recommended right now just because things could still happen to throw off timelines. The copy of earnest money check or the promissory note. For your protection, get a home inspection, the removal of contingencies, and then your escrow letter. And then, of course, all of these other addendums as needed. Okay, so getting started, we will start with our offer to purchase real estate and acceptance. So as always, the buyer goes right at the top. You put your client's name there, and then the address of the property and the parcel number. Any of the things that are included here, obviously all of the mechanicals are already put in there in the boilerplate language, and then just really checking the MLS to make sure that you have everything listed here that is going to be included. Something newer to our contract is that we have this part that is chattel included in the agreement, and then also fixtures excluded. It's a little more specific than our old purchase agreement was. And again, if you have any questions, please just feel free to unmute yourself at any time. This can be pretty informal. Secondary offer, if it's a secondary offer, you would note that here, and then you would put the date that that offer was good until. The earnest money would be deposited within 4 days from the date of receipt of the release, notifying the buyer that they are the primary offer. And the buyer can terminate the secondary contract at any time before they receive that, with written notice to the seller. So then you put in your purchase price, earnest money. This has been changed up a little bit, which I think is good. We have the option now for wired funds to the escrow agent, or a check made payable to the escrow agent, or a note, which would be that promissory note, which would say that we would get the earnest money to them within 4 days from acceptance of the offer.
I have a question on that. Is this a personal check that they accept here in Ohio?
So if it has to be under, it has to be 1,000 or under for that, I believe. And every title company, some title companies will require like a certified check. Some title companies will accept a personal check. So I would just verify when you send the contract, just make sure that you know how the best method is. But a lot of title companies will just prefer that you wire it, especially, and it has to be wired if it's over $1,000. So,
okay.
Great. And then cash down payment and your mortgage loan, and then the types of loan as needed. And then the other could be anything like USDA, or if there's a special program that they're going through that you need to specify. A lot of questions have come up about on this new purchase agreement where to put the closing costs if you're asking for any to be paid. And the answer is that you can add a text box right here if it will let you, or just create a blank addendum to the purchase agreement, and you can write in the requested closing cost there. Okay, the parties direct the escrow agent to confirm receipt of the earnest money with written notice. And then it says Ohio law requires escrow agent deposits in excess of $10,000 to be conveyed by wire transfer. Okay, and then this right here used to be a separate addendum for us. This is our wire fraud addendum, now incorporated into the offer to purchase. So basically, it just warns against wire fraud and releases us from any damages or claims based on if they were to wire their money to the wrong person. So definitely important to go over that with your clients to protect them and to protect yourself. Okay, our financing paragraph. This offer is conditioned upon the buyer making written application, usually within 5 to 7 days is what I have typically done. And then obviously if you're writing the offer on a weekend, you build in a couple of days there just because they might not be able to get with the loan officer, especially if you submit it on a Friday night or something like that. Written loan commitment, that's usually about 3 weeks or like the week before closing. If they don't obtain the written loan commitment, then the agreement is null and void and the parties sign a mutual release. Ohio law requires the escrow agent to hold the earnest money until that mutual release is received that tells where it should go, or a court order, and that's usually about 2 years if that has to go that far. For closing, all funds and documents to complete the agreement are placed in escrow with the lending institution, or this is where you would put your title company on or before, and then your closing date and your title transfer date. For the walkthrough, usually people put in about 1 to 3 days. That's, based on, that gives you a little bit of a range. Instead of putting just 3 days, I typically put 1 to 3. And so we added a little bit of verbiage in here, just that kind of makes the walkthrough a little more clear. So it's absent normal wear and tear. They're just looking at the condition to make sure that it is in the same condition of when they last saw it. If there is a material adverse change, then the buyer notifies the seller and escrow agent in writing, and then the parties can agree in writing whether the buyer will be credited or if the seller proceeds will be withheld. And then any failure by the buyer to conduct a walkthrough is the buyer's absolute waiver of it and the acceptance of the property in its as-is condition. So it's good that we have that in there, because then you can go over that with your client at the time and say, I'm going to remind you to do a walkthrough, but if you don't do a walkthrough, then there's nothing, we don't have any recourse whatsoever if something is not the way you expected it to be. That's also a good time to check for any repairs that you had requested, just to verify that those are completed. For possession, the seller shall deliver possession and occupancy to the buyer on or before 6 p.m., 0 days after the recording of the deed. Or if you set up some type of delayed occupancy with the sellers in your offer, then that would be where you would put that. And then it states that the buyer shall transfer utilities commencing on the date of possession. For title, just the basic language here that they will convey marketable title by general warranty deed or fiduciary deed if required, releasing all dower, liens, and encumbrances except for any mortgage that the buyer would then take, any restrictions, conditions, and easements and encroachments that do not materially adversely affect the use or value of the property, any zoning ordinances, and then taxes and assessments, both general and special, not yet due and payable. The seller furnishes an owner's fee policy of title insurance from the escrow agent for the purchase price with the cost of the premium split between the seller and the buyer. A lot of times people have questions about that. So if they want to know, it's right there in our contract. The seller has 30 days after written notice to remove any title defects, and then the buyer can either accept the title subject to each defect without a reduction in purchase price, or terminate the agreement. And if they terminate the agreement, the mutual release authorizes the earnest money to be returned to the buyer. Who has actually read through our whole purchase agreement before? Show of hands. Okay. Prorations. Tenant security deposits shall be credited through escrow, rents, and this just goes through anything that would need to be prorated. The escrow agent makes good faith estimate of taxes to be owed, and reserve sufficient funds from the seller's net proceeds to pay those taxes when the title transfers or what comes payable after the title is transferred. The escrow agent is instructed to release the balance of funds on reserve upon notice from the county auditor that taxes on the land and improvements have been paid in full with the date of title transfer. This is where you would put in any water or sewer hold. Obviously, if it's a septic or well property, then you don't have to put anything here. And then the agricultural tax recoupment, I don't know about anyone else, but I've actually never had a property where this applied. But I recommend putting seller just because it protects your buyer in this situation from anything that could possibly come up down the road in the transaction. Charges and escrow instructions. The seller shall pay the following costs through escrow. So they pay their transfer tax, any amount to discharge their mortgages, liens, and encumbrances that haven't been assumed, title exam, and 1/2 of the premium for owner's fee policy of title insurance, any prorations due the buyer, so anything closing costs, prepaids, points that you asked for, the broker commissions, and then 1/2 of the escrow unless FHA and VA regulations prohibit payment of escrow fees by the buyer, in which case the seller shall pay the entire escrow fee. So the seller shall directly pay all utility charges up until title transfer or possession, whichever is later. So if you do have a specific situation where the possession is delayed, the occupancy is after the seller is keeping occupancy after title transfer, then that would protect your buyer there, that it says that they must pay their utilities through that time. Tenant security deposits, if any, shall be credited to the buyer. The buyer pays, unless prohibited by FHA or VA, 1/2 of the escrow fee, 1/2 of the cost of insuring premiums for owner's fee policy of title insurance, all recording fees for the deed and mortgage. And then the buyer's agent commission is comprised of 2 components: the cooperative compensation that is listed in the MLS that we get, and then $200 from the buyer through escrow. So if you're on a team and this fee looks different, it will be like that on your purchase agreement. But the one that is typical for our office for solo agents is $200. So make sure you go over that with your client so they're not surprised at the end. The buyer elects or doesn't elect to a limited home warranty from whatever company. The one that we have a relationship with, obviously, is America's Preferred Home Warranty. And then you would just put the cost of that if they had any add-ons or anything like that. Currently, the cost of the base warranty is $425. And then you would select if it is paid by the seller or the buyer at title transfer. And then the parties acknowledge that a limited home warranty does not cover pre-existing defects and does require the buyer to pay a deductible in the event of a claim. That's new language in our purchase agreement, and I think it's really good because it helps us to kind of explain to them that a warranty does not make problems go away that are already existing, and that it's not a free repair. They still have a deductible to pay. And that we also receive a fee from the warranty provider. That's something that was never there before either. But since we are paid on warranties from America's Preferred Home Warranty, that's why that is in there. Any questions so far? Okay. Inspection. This agreement is subject to the buyer's inspection as elected below, which shall be conducted from an independent professional inspector of the buyer's exclusive choice within specified number of days from the date of acceptance as herein defined. While the broker and agents may suggest or refer inspectors or contractors to the buyer, and if you do that, it should always be at least 3. The buyer should be solely responsible for choosing and retaining any inspector, contractor, or other service provider. The buyer acknowledges that the waiver of any inspection or evaluation of the property is against the advice of the broker and agents. And the buyer is advised that real property may have latent and hidden defects and conditions, so they must inspect and make diligent inquiry about the property, including the land, dwelling, and any improvements. The buyer should inspect and evaluate all aspects of the property and retain independent professionals to do so on their behalf. So when applicable, it should be a licensed home inspector. That is a recent change that went into effect in our state. We did not have a licensing program. There were InterNACHI and ASHI certified inspectors, but now we have an actual licensing program through the state of Ohio. And so you should always have a licensed home inspector to inspect any properties. The buyer should review public records and consult with local and county government about the property, including without limitation as to the buyer's intended use. So any zoning issues that could be coming down, any regulations with, how things can be built if it's vacant land or something like that, which would be on a different agreement. The buyer should carefully review seller's representations and disclosures and make inquiry of seller if additional information is deemed necessary for their due diligence. The buyer should not rely upon any written or verbal representations of the broker and agents. The buyer agrees to hold the broker and agents involved in this agreement harmless from any and all claims, actions, injuries, or damages relating to the property after title transfer. So that's good because that protects you as well. Please note that the inspections required by any state, county, local governments and or FHA and VA, including FHA appraisal and municipal point of sale inspections, which we're very familiar with in the Cleveland area, they do not replace the need for the buyer's own inspections. Here's where you would select any inspections, typically 7 to 10 days. If you can do it faster in a competitive situation, that's always going to be beneficial to you. Here's where they can waive all of the inspections that they did not select. And I always recommend in other to put as recommended by general inspector, because that protects if they didn't think that they needed, for instance, a wood destroying insect inspection, then that protects them if the inspector finds something that looks like it could be evidence of wood destroying insects, and it allows you to do further investigation. Also, if they saw something that looked like mold and you wanted to further investigate that before making a decision, then that protects you there as well. So within 3 days from the date that the last inspection is completed, the buyer shall elect only one of the following options: to remove the contingency and accept the property as is. So that means no further action is needed. To accept the property subject to the seller's repair of specific conditions or defects identified in a written inspection report by a professional inspector or contractor. Or to terminate the agreement if it's just too much stuff and they don't even want to move forward with the property. Hopefully those things that are too many to deal with are huge issues that they just can't see themselves moving forward, because you want to make sure that you're not backing out for, things that would be easily remedied at that point. If the property is accepted in as is condition, the buyer shall sign an amendment to purchase, removing the inspection contingencies, and the agreement proceeds in full force and effect. If the property is subject to repairs, the buyer shall provide the seller with a copy of the inspection report and the amendment to purchase agreement identifying which defects need to be repaired. Then the parties have 3 days from the seller's receipt of the list and the inspection report to agree in writing which defects, if any, will be corrected at the seller's expense. And if they cannot agree within those 3 days, then the agreement is null and void and the parties sign a mutual release and the buyer gets their money back for earnest money at that point. So you have 3 days to get any repair requests or remedies to the seller. And then once the seller has received that, you have 3 days to come to an agreement. If the buyer does elect to terminate the agreement based on newly discovered material latent defects in the property, then the buyer shall provide a copy of the written inspection report to the seller, and the parties shall promptly sign a mutual release authorizing the earnest money to be returned to the buyer. So they do have that strength in the ability to back out after an inspection. The parties can modify the dates for inspections, repairs, or the deadline for exercising their right to terminate the agreement by mutual written agreement. So a situation where that could happen, if you're having trouble finding a licensed home inspector to inspect the home and you thought you could get in within 5 days, but that's not happening, you could ask for an extension on that. And then any failure to request review of repairs before title transfer is an absolute waiver of the review and acceptance of the property as is. Okay, the pest and wood destroying insects inspection. It lets you choose if it's at buyer or seller's choice and at buyer or seller's expense. And it does note in here about the FHA and VA regulations that prohibit payment by the buyer, in which case the seller shall bear the cost, especially with repairs and treatment. And this agreement can be terminated if by the party paying for the repair and treatment if the cost exceeds $500. So even if your buyer says, I'm willing to take care of any, expenses related to wood destroying insects, if they find out that the cost would be over $500, then they would be able to back out at that point. Lead-based paint. So a lot of this, typically, I don't think people do this just because it can be extremely time consuming and costly to do a lead-based paint. So I would say there are probably situations in which you would want to do that. And I would just go over this paragraph with your client and also make sure that they've received the lead-based paint disclosure. So in the event that existing deficiencies or corrections are identified by the inspector, then the buyer has the right to terminate or request that the seller repair the specific existing deficiencies noted on the inspection report. Okay. So if you haven't received it, then I would say that you'd want to receive that within 1 or 2 days after the acceptance of the offer. Megan's Law, so that is the sex offender registration. That is your buyer's due diligence to inquire directly with the local sheriff's office or Ohio Attorney General's office. The condition of the property, the buyer has examined the property and agrees to purchase it in as is present physical condition, including any latent defects and defects disclosed by the seller on the property disclosure. And then the seller should promptly notify the buyer in writing of any additional defects or disclosure items that arise between the date of recording the deed. So we have an additional addendum in our listing agreement, in our listing folder, that is for making any changes to the property disclosure. So instead of making the changes directly on the property disclosure, if something comes up throughout the transaction, it's recommended that you use that addendum and have the seller complete that to disclose any additional defects. So this just states that they've received the property disclosure or have not received it yet and will receive it within however many days. Again, you want that pretty quickly. The seller shall deliver possession of the property in broom clean condition. This takes the place of our walkthrough agreement. We used to have a separate addendum as well to make sure that it was broom clean, but that's now in our contract, which is great. Free and clear of all debris and chattel. The seller shall pay all costs for repair of any gas line leak between the street and foundation at the time of the transfer of utilities, and comply with any governmental point of sale laws and ordinances. The buyer should inquire directly with the applicable local government if the buyer wishes to review any point of sale inspection information and public records. The seller represents that they have not received any notices about building code and health and safety violations except as disclosed. And then if that applies, the buyer and seller have however many days after receipt of buyer of all notices to agree in writing which party will be responsible for the correction of any building code or health violations. So this protects you if the point of sale has not yet been completed on a property for that city required inspection. So if that is scheduled, then I would recommend that you give yourself plenty of time for the buyer to be able to see that. And then if the seller is not, especially in situations where the seller has said that it's as is, and they will not be taking care of any point of sale violations, then you really need to know that for your buyer because you don't know what that's going to look like yet. And they need to have the chance to say that they would like to terminate the agreement. And if they cannot agree in writing in that time period, the agreement is null and void by either party. We're almost there. I know this is a little dry, so please interrupt if you have any questions. I feel like I'm just listening to myself talk right now. Representations and disclaimers. The seller agrees that the seller has completed the property disclosure without any assistance and having otherwise disclosed any additional information about known material conditions and defects in the property, including the land and dwelling unit. The parties hereby release and to indemnify and hold the broker and their agents harmless from any and all claims, actions, injuries, or damages relating to the property, including misrepresentations or omissions of the seller. This whole paragraph is just protecting you, saying, hey, there's only so much we know about any given property. The seller told us what they told us, and the seller's agent is not liable if that was not true and they had no knowledge. And we cannot know everything about every property. So it is up to the buyer to do their due diligence. If there is damage in excess of 10% of the purchase price before title transfer, then the buyer can accept the insurance proceeds and complete the transaction, or terminate this agreement and receive the return of all deposits made. If the damage is less than 10% of the purchase price, then the seller should restore the property to its prior condition. Okay, any addenda and related documents. So we have, of course, the agency disclosure, the property disclosure, any financing addendums, condominium addendums. So even if you have a house with an HOA, you would put that form there, lead-based paint, and then other. So that could be an escalation addendum, seller occupancy after title transfer, a blank addendum that states that there will be closing costs, any point of sale things there as well. Okay, binding agreement. Calendar days, that's important, not business days, calendar days. Acceptance is when the latter of the parties sign this agreement without making material change, and then delivers either written or verbal notice of such signatures to the party or that party's agent. The parties agree that the broker and agent in this transaction have no authority whatsoever to bind them on the purchase or sale of the property verbally or in writing, including by email or text. And then upon acceptance, this offer and all attachments and addenda shall become an agreement binding on the parties, their heirs, executors, administrators, and assigns. The terms and covenants, conditions, and provisions of this agreement to be performed by the seller shall survive delivery and recording of the deed. So again, it's a legally binding contract. Please review it before signing it. If there are questions of law, they should get a lawyer for themselves. Okay. Your buyer will sign here. You'll put your information here for contact. Earnest money deposit receipt. Please never ever sign this unless you have it in your hand. So if you had them fill out the promissory note and you check this box, then you could sign it. If they gave you a check directly, which I would highly recommend not having them do, just because the further away you stay from earnest money, the better. So in those cases, go ahead and sign it. But if you did not receive something physically in your hands or on the computer screen, then do not sign this at all, because if that earnest money does not exist, then you could be held liable because you said that it did. Acceptance. So this states that the seller's proceeds will pay the commission agreed with the seller's brokerage with cooperative commission offered by the seller's brokerage to the buyer brokerage through the MLS. Sellers will sign here. Listing agent, you'll put their information here. And then here is where you will put all of the listing agent information and selling agent information, which is you. Any questions at all on offer to purchase? Okay. Oh, I see a chat. Nikki says no. Thanks, Nikki. Okay. Next up is our residential listing loop checklist. So again, consumer guide to agency, the MLS printout, the tax and legal, including deed or the realist printout and the MLS. We have that handy tab right there. Exclusive right to sell agreement, the residential property disclosure or exemption, the lead-based paint addendum, again, the Ohio Real Title ABA to show that our office has a relationship with Ohio Real Title, the America's Preferred Home Warranty, either accepted or waived. Even if there's another warranty company that you like to work with, we should still have the America's Preferred waived in that case. COVID showing addendum, I like this form a lot, just because it is useful to allow you to know in advance if the seller is comfortable with FaceTime showings or video chat showings. And it kind of lays out some expectations in advance as well. So I think that that's really useful, because then if a buyer's agent contacts you 10 minutes before they're showing and says, hey, they want to FaceTime their mom who lives on the other side of the country, is that okay? Because they should be asking for permission to do that in a seller's home. Then you already have the answer because you talked about it with your seller in advance. And then the condominium cluster or PUD information from the seller, if it's an HOA or condo. As needed, all of these different forms, if it's an LLC or there's a power of attorney or executor or anything like that, we want to see those documents just to make sure that you have it. Anything here, if you're on a team or something like that, it's highly recommended that you put the agency disclosure in the supplements in the MLS when you have a listing, just because if there are more than one licensee who's involved in the transaction, who's going to touch the client in any way, and you're licensed, all of those people should be listed on the agency disclosure. And any status changes, the winterization ladder acknowledgement is pretty important at this time of year. If it's a vacant property, it's recommended that you have that filled out, just to say, we plan to acknowledge, we plan to winterize this property, or we do not plan to, and we accept the liability knowing that the pipes could burst, and that would be a lot of damage. Any additional ABAs, and then unfortunately, if you had to have a release of listing agreement, we never want that. Okay. Our exclusive right to sell agreement. This one is much shorter than the purchase agreement, so that's always good. Okay, so you would put the seller's names here. Is the owner or having the lawful right or power to act for the owner in the following property. And we are authorized as Keller Williams Living and the sole and executive right to offer the property for sale on the price and terms outlined below, or such terms as may be agreed by the seller. So here's where you'll put the property address and the city, the listing price, and then the listing term. So I don't know why that auto-filled there, but that's fun. So typically I would say do at least 6 months, just because 3 months is a little tight if you have, you know, a longer closing or anything like that. I typically tell people 6 months or longer. Listing price, exclusive right to sell, and compensation. So in consideration of the broker's agreement to work to secure a buyer for the property, the seller grants the broker the sole and exclusive right to sell the property. The seller shall refer to broker all real estate licensees or prospects who may contact the seller during the exclusive period or any extension of it, and promptly notify the broker in writing with all information relating to such inquiries. In the event of a sale or exchange of the property at the price and terms stated, or such price and terms as may be acceptable to the seller shall pay the broker. So here's where you would put whatever your commission is. This space here is to write it out in words. This space here is to just put it numerically. And then a minimum fee. If it's a lower priced property, a lot of times people will put a minimum commission in here instead, just because if it goes much lower, that percentage might not get you very much money at all to cover your costs for listing and also just to get paid. So you can put that there if that is what applies. The foregoing commission shall be paid by irrevocable, I know I butchered that, assignment through escrow at title transfer. In the event of the sale or exchange of the property within 6 months after the expiration of the exclusive period or any extension of it, the seller shall pay the commission described above if the buyer had contact with the broker or cooperating agent about the purchase of the property during the exclusive period or any extension of it, and the seller knew of such contact. However, the seller shall not be obligated to pay said commission if the seller enters into a bona fide written exclusive right to sell agreement with another real estate brokerage during the protection period. So basically, if someone cancels their listing with you and one of the people who viewed the property during the time you had it listed comes to them as their for sale by owner, and they're like, okay, now we actually do want to buy this property, then the sellers would still owe you a commission if they were procured during the time that you were listing it. But that does not apply if they immediately, after they are released from the listing agreement with you, if they say, we just weren't feeling like we had a good connection, but we're going to go list with another realtor, then you are not entitled to commission during that 6 months. Cooperation. This is where you will put what you are putting in the MLS as the cooperative commission for the buyer's agents. Authorization to market. This just shows that the seller is granting you the sole and exclusive right to publish and to grant others the right to publish any and all descriptive information about the property, print, video, audio, photographic, and electronic descriptions. The broker enters the property into the multiple listing service subject to MLS rules and regulations. The seller authorizes the broker to have taken at its expense interior, exterior, and or drone photographs of the property, and to have photographs digitized, reproduced, published, broadcast, disseminated, and displayed in any manner or form, including without limitation on and through any MLS, the internet, as well as any media or means. The seller releases the broker, its employees and agents from any and all liability arising from or related to access for showings and the use, distribution, publication, or display of any property information. They authorize us to put a for sale sign and lockbox on the property and to provide reasonable access for showing the property to prospective buyers and sellers or tenants. The seller authorizes third parties, inspectors, appraisers to access the property by lockbox or any other means with advance consent. And that consent should be in writing as well. So if you can't meet the appraiser there for some reason and they ask for a lockbox combination, you should email, not text your seller after talking to them about it and what that would mean, and say, do I have permission to provide the lockbox combination to this appraiser on this date at this time? And then have them respond yes. Fair housing. This is in every single contract forever. Just don't discriminate based on anything. Just that's all. The seller disclosures. The seller understands that the broker is relying on the seller to provide information to the broker that will be used to publicly advertise the property. The seller shall access and review multiple listing information to confirm its accuracy and immediately notify the broker in writing of any errors or omissions. Does anybody do anything with this right now as a part of your pre-listing process? Do you print out, like the incoming MLS form and email it to them and say, hey, please let me know if all of this looks accurate. If there are any changes, please let me know. It's a pretty good idea to do that just because then you have, again, a paper trail to protect yourself.
Yeah, we always had to do that in Washington. We had to have them initial the MLS.
That's a great idea. I think that's a really smart thing to do, just because then you have proof that even before it was available to the public eye, that the seller confirmed that all of that was accurate. So that's a really good idea. I'm glad that you were doing that in Washington. That's really cool. Okay, the seller shall accurately complete the Ohio residential property disclosure form without assistance from broker or listing agents designated below, and shall promptly notify and provide listing agent with written disclosure of any other material defects, conditions, or changes in the property's condition, which are or may become known to the seller including without limitation, inspection reports, building department, and health and safety notices. The seller should complete the federal EPA lead-based paint disclosure and addendum if the property was built before 1978, and shall disclose any notices received from the local sheriff's office pursuant to the Ohio Sex Offender Notification Law. The seller acknowledges that they may be liable to a buyer if known latent defects are not disclosed. In the event of any claims or causes of action alleging the seller's failure to accurately, completely, or timely disclose, the seller shall indemnify and hold broker, agents, employees harmless from any and all such claims, actions, expenses, and damages, including attorney fees. So basically, this is telling them, don't lie. If you do, it's not something that we have any control over. The seller warrants that there are no encroachments, pending lawsuits, foreclosures, divorce actions, assessments, tax, utility, or mechanic liens, or any other matters that could delay or prevent a seller from providing clear title and or occupancy to the property, except. So some cases where this could take effect, if it is a property that is going through probate and you want to make sure that everything is going to be good there. If everything that's listed up here. So if they know of something, this is where they should tell you there is something with this property that could cause the closing to be delayed. The seller has received and read the Consumer Guide to Agency Relationships and will direct any questions to the listing agent or broker. Ohio law requires the broker to keep confidential information that the seller designates as such unless disclosure is required by law. So if it's a material defect and they tell you, then that's not confidential anymore. If it's how much they would take, what their bottom line is for the sale, that's confidential unless they have told you, you can advise buyer's agents that this is the lowest we would take. Anything that they tell you that you can tell the buyer's agents about, we would prefer a closing on such and such date, or we need to, obviously, if they need to find a house, or anything like that, then that is something that if they have given you permission, then you are able to disclose. Electronic surveillance. This is relatively new in the last couple of years. They need to disclose if they do or do not have surveillance equipment. And it states that Ohio law prohibits a seller from using electronical, mechanical, or any other device to listen, record, or otherwise acquire content of the oral communications of other persons without the consent of at least one party to the communication. So this is also something that I go over in my buyer consultations too, just because if a seller doesn't disclose that, you still want your clients to know as buyers as well. So this just tells them that they are supposed to disclose that. Because it's impractical to obtain such consent from all parties entering the property for showings, open houses, inspections, appraisals, etc., the seller shall disable the audio function of any surveillance device in advance of any access of the property by third parties. So video is legal in Ohio, audio is not. Excluded fixtures. So if there's anything that they do not intend to convey, so if they just got a brand new refrigerator in the kitchen and they really want to take it to the new house, that should be noted here. If the chandelier in the dining room is their grandma's and they want to take it, that should be noted here. Or the best case is just to replace it before listing it, and then you don't even have an issue. Limited home warranty. So if they are going to offer a home warranty, whether through America's Preferred or if you do happen to have a different company you like to work with, at the cost, and then it's paid through escrow at title transfer. Seller acknowledges that the warranty is limited and requires the payment of a deductible, and the broker or listing agents may receive an administrative service fee for the warranty if provided. Everybody loves a point of sale inspection, so this is in here as well, especially in our area. If the municipal or county point of sale, rental, or any other inspections of the property are required in connection to the listing or sale of the property, the seller shall promptly arrange for them at the seller's expense. Provide the listing agent with complete results and or compliance certificate, and deposit that result or compliance certificate before title transfer with the title company. because they won't be able to transfer title without it. Security, insurance, and maintenance. So this just, they're still responsible for the property and its contents, utilities, safety, security, property and contents insurance, and general maintenance during the term of the agreement. They agree that the broker and its agents are not managing or monitoring the property. And if it is vacant or unoccupied, the seller agrees to winterize the property during cold weather and ensure the temperature is properly set. So that winterization letter, if they say, no, I'm not going to do that, I'm just going to go check on it all the time, then I would definitely make sure you have them sign that to make sure that they know that that would be their liability in that case. Because third parties may access the property for showings, inspections, appraisals, etc., the seller shall store, remove, and/or secure all valuables during the term of this agreement. The seller hereby releases the broker and its agents from any and all claims, injuries, damages, and causes of action relating to or arising from the foregoing exclusive obligations of the seller. Electronic data security, again, that's our wire fraud addendum, but in our agreement so that it doesn't get missed. Don't ever wire anything basically without confirming the information for where it is going, and that we are released from any and all claims, damages, and causes of actions related to the unlawful electronic data security access by a third party. And it's a binding agreement. Get legal advice if necessary. And then you have them sign, make sure that you also sign it so that it is effective by the listing date. And that's it. Any questions about anything? Any other forms? Any other specific questions with it? Okay, if there's no questions, thank you for joining me today. I hope that was helpful, and I will see you all later.
Thank you.
Bye.
Thanks, Katie.
Aye.
Bye-bye.
Welcome. Bye-bye.